everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Characteristics of United States Maritime Law. The maritime law of the United States is different in several interesting aspects from that of the other leading maritime nations. The history and nature of these differences have been frequently examined, but many important changes have occurred as the law grows and changes under the impetus of our great new American maritime activity. It is therefore opportune to re-examine some of the more important points, and especially those which have developed and changed during the past 20 or 30 years. The following topics will be considered. First, basis and nature of the federal admiralty jurisdiction and its relation to the common law or court jurisdiction of the states. Second, nature of the maritime line. Third, practice in realm, including steps which can be taken to release the rest. Fourth, practice in persona with admiralty attachment of property, including steps which can be taken to release attached property. Fifth, divided damage. Sixth, some seamen's rights, including those of alien seamen in foreign flagship. 7. Sovereignty immunity. 8. Death claims as distinguished from claims for bodily injury. 9. General average and the negligence clause. 10. Limitation of ship owners' liability. Finally, some reason why litigants prefer to utilize the methods and remedies of the maritime law and the admiralty practice in preference to the landwise methods of our common law and court law courts. The strong revival of shipping, both under the American flag and under 40 or 50 foreign flags, may give this survey a practical value. The development of admiralty jurisdiction and maritime law has been the subject of many studies by noted American legal authors, and its history has been traced by learned judges in their opinions. Earliest was Judge B., who presided over the federal court in Charleston, South Carolina in the years 1790 until 1812. His opinion carefully stated the European source from which he derived the principle for his decision. In New England and on the Supreme Court, Justice Story in the years 1811 until 1845 expound the historical sources of the American maritime law. Of him, Professor Parson wrote in 1859, Story could not find all this true or original principle of admiralty or of the law of shipping in English law. He followed the lead of Mansfield, and when where they could be found, went to the continental Europe. He went with a freer step than Mansfield. His opinion in the Lovo v. Boyd delivered in 1815 remains a classic. The first edition of About on Shipping, printed in London in 1802, was well known to early American judges, and the preface of the great work, which paced through 12 editions in 80 years, direct the student to the sources of maritime law in these words. The absence of general and established code of maritime law, or in England, which almost every other European nation possesses, seems to render a collection of the principal points of that law peculiarly necessary. An operative system of justice must consider three aspects. First, jurisdiction of the person sought to be controlled and the subject matter of their lawsuit. Next, a set of rules of substantive law, stating rights and duties. And third, A system of practice adjective or procedural law stating the methods, sanctions, and penalties by which they may work out their respective rights and duties in court. This becomes quite a complicated matter when two or more sovereign states may have conflicting or overlapping jurisdiction, statement of substantive law, and system of practice. In a federal union of states, such as ours, these difficulties are capable of adjustment by means of the common constitution with its federal legal structure. In many ways, the federal legal powers is limited. One of its unlimited aspects is its power in admiralty and maritime matters. The maritime law is an exclusively federal law, and when the federal maritime law is applied and administered in the admiralty court, it is an exclusively federal practice. The influence of the state law and practice is very small. The reason is simple. The maritime commerce is predominantly international and interstate and requires a single rule of law for the whole nation. The federal district courts find the maritime law and the limits of admiralty jurisdiction in history and custom. They make such rules of practice as they find needful. A United States judge sitting in admiralty presents a position rarely found in the modern world, a court with constitutional power to find the law where it pleases largely unaided by any code or statute, and to regulate its practice as it pleases. The customary and historical sources of maritime law are a blend of all the European traditions, Amalfi, Barcelona, Oleron, Hanseatic cities, Wisby, the Colbert Code of 1681, and the English Admiralty prior to 1789. This is referred to as the general maritime law of nation, and it is broad basis of maritime and commercial law of the present times in all the trading nations. In the United States, this general maritime law means the law and custom which prevailed before the independence of the United States in 1775 until 1789. The reader will notice that the United States judges do not consider the Code Napoleon as historical source of our law, nor have they regarded any of the more modern codes as authentic source of our maritime law. The 19th century's Code of France, Italy, Spain, the Netherlands, the 19th century reforms in England, the German Code of 1900, or the work of the Comet and Maritime International since 1897, despite their no venerable age, are not yet history and do not yet express custom. As the year 1789 has gradually receded into the nearer past, the peculiar American blend of old tradition of 1789 has been developed through judicial decision. Here we trace the growth of a series of self-proclaimed extension and self-imposed limitation on admiralty jurisdiction, law and practice, which represent a genius differing in many details from the codes and decisions of other maritime jurists of the same century and a half in other nations. The following enumeration will quickly indicate the nature of these differences as they affect the daily work of the courts and the method of conducting maritime business. As to torts, admiralty jurisdiction is limited to those which occur in ships which are afloat and which are maritime in the geographical sense, namely occurring on the water. Yet, there are some curious fictions, such as rule that a dry dock from which the water has been withdrawn remain a place in the water. until quite recently, tort claims growing out of injury done by a ship to objects on land were not regarded as maritime, and many hair-splitting decisions resulted. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.